with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
Good morning. It is Saturday, March 23rd, 2024. My name is Jim Santelle. I'm with you this hour, also the next hour, on our newly restyled, our reimagined program, Saturday morning, talking with you from the studios of WAUK in downtown Waukesha, but reaching out to broadcast stations of Civic Media throughout the Wisconsin area and beyond. I am here in the studio with my extraordinary producer, Anya. And together this morning, we're presenting to you the first in hopefully a long series of newly styled programs. A lot of the content, a lot of the substance, much the same as it has been before, but some new styling, some new packaging, some new ways of thinking about what we do here every Saturday morning. This is our 90th broadcast on the networks of Civic Media since our start way back in June of 2022. Today, we're building on those foundations, both stylistic and content-related, of our Saturday morning broadcasts, formerly known as Morning Cannolis. And today, this modestly restyled information and civics-centric program, continuing to focus on those core goals and aspirations that have been a part of our broadcast since we went on the air in June of 2022. What are those? We're going to continue to focus on the identification and hopefully clear exposition of some of those most important news stories, so those events in our lives in the areas of law and government and courts, and yes, the delivery of justice as well. In addition to that, explanations, descriptions of the reasons why all of these local, national, and yes, worldwide events are relevant, why they're meaningful, why they're significant and important to our lives. Third, an examination, an explanation, if you will, of the practical trappings and specific aspects of the legal, the governmental, and rule of law issues in these news items. We're going to be spending some time today talking inside one of those cases about specifically those kinds of trappings. And finally, hopefully, some instructions, some perspectives on the intersection of the law, both procedural and substantive, with what? With civic responsibility. That's why you've come here in the morning, in the engagement with our community. Now, our new name for our Saturday morning broadcast, Amicus, a law review with me, Jim Santelle. Thrilled to have you with me this morning, hopefully for both hours. Let's talk about where that name comes from initially. Let's talk about why we've decided to rename our show just this. Amicus Curiae is an individual and organization that is not a party to a legal case, but is permitted to assist a court by offering some relevant information, some expertise, or some insight that might have some bearing on the issues in the particular case. That's how it's often described inside legal circles. The phrase amicus is legal Latin, and the origin of the term, believe it or not, has been traced way back to 1605, maybe as late as 1615. The scope of an amicus situation generally found in those cases where there's some broad public interest, and the concerns might involve things like civil rights, human rights, those kinds of things we've seen a lot in courts in America in contemporary times. In American law, amicus curiae typically refers to what in some jurisdictions is known as an intervener, somebody who's coming into the case for the first time. That is a person or an organization who requests from the court, you have to get leave of court, to provide some legal submission, some writing, some document, so as to offer a relevant alternative or some additional perspective regarding the matters in dispute. In some other jurisdictions like Canada, amicus curiae is a lawyer who is asked by the court to provide some legal submissions, something about the case before it that would not otherwise be argued by the attorneys, by the counsel, by the parties who have legitimate but relatively narrow interests in succeeding on the merits of their cases, because one or both of the parties is not represented by counsel. That could also be the case where the court also wants to have some input from some outside source. One of my favorite quotes about what amicus is all about comes, believe it or not, from Great Britain. The Queen's Bench there Lord Justice of Appeal Cyril Salmon said in Allen versus Sir Alfred McAlpine versus Sons Limited, a case in 1968, he said, I always understand that the role of an amicus was to help the court by expounding the law impartially, without partisan view, or if one of the parties was unrepresented, by advancing the legal arguments on his behalf. Once again, providing this assistance, this help, this informative direction for the court that might not otherwise come from the pure representations made by the lawyers in the case. Sometimes it does, but not always. The situation of having an amicus curiae, often noted in the press, is when an adversary or advocacy group of some kind files a brief in a case before an appellate court, typically, in which it is not a litigant. Appellate cases, of course, normally limited to the factual record that comes up from the trial court, the district court below. And attorneys, of course, as I already indicated, focus on the facts and the arguments that are most favorable to their clients. And that's legitimate. That's how our system works. That's what we embrace in our system of justice here in the United States and in many other nations throughout the world. But when a case has some broader implications, amicus curiae briefs are a way to articulate those concerns, to get those issues, those perspectives to the court, so that these possibly broad legal or public policy issues, implications of what the court might do, the anticipated decisions, are informed by that additional information that comes from this additional source, this amicus, not dependent solely on the positions and the arguments that are advanced by the parties involved in the case. In the United States Supreme Court, which we're going to be spending a lot of time today talking about, the United States Supreme Court also has special rules for amicus petitions. Amicus curiae briefs sought to be filed in cases pending before it. Happens all the time. Supreme Court Rule 37, there it is. Here's your first piece of Supreme Court practice for you this morning under the rubric of our newly styled show. Supreme Court Rule 37 states in part that an amicus brief should cover, quote, relevant matters not dealt with by the parties, which may be of considerable help. Considerable help. In fact, the cover of an amicus brief has to identify which party the brief is supporting, or if the brief supports only some affirmance or reversal, got to tell the court what it is your ultimate position is, even as you're providing this assistance, this direction from this additional source. The court also requires that all non-governmental amicus briefs identify those providing any monetary contribution to the preparation or submission of the brief. Why? We've talked a lot about this on this broadcast. You want to know if indeed the particular group that's filing an amicus brief that is represented by an amicus in the case has some financial interest in that. That's important. That's relevant to know for the court to understand when it takes a look at the positions being presented in the particular brief. Briefs have to be prepared in a booklet format, and 40 copies must be served upon the court. All of that for all of your assistance, so that when each one of you seeks permission from the Supreme Court under Rule 37 to file an amicus brief, an amicus brief in front of the Supreme Court, you know how the process goes. In the United States Supreme Court, unless the amicus brief is being filed by the federal government, and again, the federal government, the Solicitor General of the United States of America, has special dispensation not to get permission. In all other cases, permission of the court by means of a motion to leave. You have to file a specific petition with the Supreme Court, asking the members of the Supreme Court, can we please file an amicus brief with you? Or there has to be some mutual consent of the parties. Some of that is generally required before you can simply file a brief. So even though I'm encouraging you to do that in these important cases coming up, you have to get permission from the court to submit that brief before the clerk of court will place it on the docket. Allowing an amicus curiae brief to present oral argument is fairly extraordinary. The amicus who writes the brief, highly unusual for that person, that entity, that legal entity to appear for oral argument. We're going to talk a lot about oral arguments today as well. And the court, believe it or not, can appoint its own amicus if neither party supports the decision of the lower court. In other words, there's nobody advocating for what happened below the decision by the lower court. The court can also appoint an amicus. That person can write an amicus brief
That has been done at least 44 times in the history of our Supreme Court. Often happens that these kinds of amicus briefs are filed routinely. We have seen that a lot in the civil rights cases, the human rights cases, including those cases presented to the Supreme Court and other courts as well in our recent contemporary history. That is your briefing this morning on the word amicus and amicus curiae, which again, this notion of providing assistance, support, some counsel, if you will, some direction on what these things mean, some perspective that may not otherwise be provided. And yes, indeed, that's the reason why we here at Civic Media have decided to embrace that as the word, as our new moniker, our new name for our Saturday morning broadcast that explains what we hope to do as a part of our presentation of the facts of cases, our identification of why those facts are important, our description of those legal trappings, and then the perspectives on engagement in the community, all of that by virtue of our newly adopted amicus approach to provide you, friend of the court, friend of this station, but friend of the community, most importantly, with information that's helpful and insightful for understanding the larger issues. That has always been our commission for the previous 89 broadcasts, and it is our commission again on this, our 90th broadcast, as we go forward under our new name, Amicus, a Law Review. More about that in the future as we talk further about what we're going to be doing here. Now, along the way, as I indicated, the fundamental content, the substance of our broadcast is going to remain substantively much the same as it has been before, reviewing those fundamental issues again in the area of law and government, courts, and the delivery of justice, the aspiration for justice, as we have often called it on this particular show. In addition to that, of course, in normal presentations, normal programs, we're also going to be soliciting your calls. We're not going to be doing that this morning because we got so much material to address, and Anya and I are going to get to that right after this coming break. We're going to talk more about our newly styled program and get into the content of Amicus, a Law Review.
You're listening to The Shaw, WAUK.
1 minute break.
For the longest time, it was hard for me to even get out of the house, much less do a backside 180. It took me a bit to understand what was going on, but eventually I learned I had anxiety. Now I'm getting help for it and feeling so much better. Sure, some days are better than others, but the whole thing about getting out of the house, that's not really an issue anymore.
Mental health care is working. See what it can do for you at mentalhealthcareworks.org. A message from the American Psychiatric Association Foundation.
The Todd Alba Show.
Our ride into spring continues. We have some great prizes to give away. A weekend getaway at Chula Vista Resort, a bike, and a three-way blender.
A 3-in-1 blender.
Oh, 3-in-1. So I misread that. We're having our own political threesome here.
Going with the After Dark show all of a sudden.
It's always a
This
pleasure.
is Civic Media, not Cinemax, Todd.
The Todd Alba Show. Weekdays, noon till 2 on your local Civic Media radio station and on the app.
You're listening to the Shaw, WAUK, Waukesha's home.
Welcome back to this, our newly styled, our newly reimagined Saturday morning broadcast. Lots of the same content, lots of the same focus. And as we go forward, we're going to still be including in our broadcasts on a regular basis, including somewhat this morning, some special segments that will occasionally populate our broadcast. Those include things like Undiscovered Justice. We've done this a lot, reviewing and considering those relevant, significant law-related developments that have not been extensively covered in the mainstream media, but that nonetheless warrant our public understanding and our appreciation. We're going to be doing some rule of law snapshots as well, some brief sort of headline type mentions of non-major events that nonetheless illustrate some significant issues in the areas of civics and justice-related points. We're also going to be talking about microscopic justice. We're going to be delving into deep inside expositions and explanations of some major news stories, often including some recitations of key quotations, some language, again, to establish a more focused civics education as a part of our role as Amicus in behalf of our community. And finally, we're going to be introducing down the road a new segment called Law Review Case Notes, invoking some components of academic law journals, kind of an expression of mine, some opinions of mine, perspectives of mine, some of which I have provided before, but a more organized way of doing that, some rational, hopefully balanced views on the significant rule of law events that we discuss every single week here on our Saturday morning broadcast. Now, in addition to those continuing aspects of our Saturday morning broadcast, of course, you're noticing some new music. Anya and my other wonderful producers putting that together for us every single Saturday morning. We're hearing at the start of our program a solo from Michael Gundlach, Gundlach. It's called Crazy Blues Jazz Piano Solo. That's the underlying music for our entry music and our entry into our broadcast every Saturday morning. A special treat today, just because it is our inaugural program under the Amicus moniker. A special treat is at the end of our second hour, at the end of this 10 o'clock hour, and our final segment before a couple of programming notes for the future. We're going to play, Anya and I, we're going to play the entire piece presented by Michael Gundlach, Crazy Blues Jazz Piano Solo, to bring out our stories of the day, to lead us out into the rest of the day at the conclusion of our 2-hour program this morning. As always, we are reaching out to stations throughout Wisconsin and beyond. I want to make special note of those stations and listeners throughout the state of Wisconsin, now a part of our Amicus family this morning through the civic media broadcast opportunities. Those include, of course, right here in Waukesha, the Shaw 101 FM, 540 AM. In Madison, our friends in Madison at Mad Radio WMDX, that's 92.7 FM, 1580 AM. In Wausau, Bull Falls Radio, WXCO, that's 98.9 FM, 1230 AM.
Wausau.
In Wausau, yes, go Wausau, right, Anya?
Yes, sir.
There you go. In Wisconsin Rapids, we've got locally grown radio, that's WFHR, that's 97.5 FM, that's 1320 AM. Richland Center, News from the Center, WRCE, that's 107.7 FM, 1450 AM. In Amory, 107.5 FM, 1260 AM, that's Lake Air, WLAK. In the great city of Oshkosh, we got the Oshkosh Air Support, WISS, that's 98.3 FM, 1100 AM. In Green Bay, the talk of Green Bay at WGBW, that's 97.9 FM, 1590 AM. In Hayward, we broadcast a bit from Hayward, and not too long ago, that's Buzz of the North, WBZH, that's 910 AM. In Racine and Kenosha, 99.9 FM and 1400 AM, also 98.1 FM in Kenosha, WRJN. In La Crosse, the Eagle, WLCX, that's AM 1490. And not to be outdone, in Eau Claire, the Tap, it's WCFN, that's 93.5. All of those broadcast stations of civic media joining us, and you can join us too as a part of our discussion here on the Saturday morning broadcast. Now, Amicus, a law review. Delighted to have you with me this morning. Let's talk more about the kinds of things we're going to be talking about just this morning. As I indicated, we're going to continue with a lot of the content, the substance of what we have done before. And that includes this morning. A major look once again at one of our common topics, and that is the United States Supreme Court. A lot of activity this past week, a lot of things to catch up on too in terms of cases that the Supreme Court has already decided. Not exclusively the Supreme Court this morning, but a lot of focus upon the highest court in the land. These 9 folks appointed by the president, confirmed by the United States Senate over time, lifetime tenure, having these dramatic impacts upon our lives and our livelihoods, as we have spoken about on our Saturday morning
broadcasts. And so this morning, we're going to spend some time talking about inventory, what the Supreme Court has in front of us right now. Talk a little bit about some of the decisions. Yes, indeed, they have already issued opinions in 11 different cases. I'm going to remind you of a few of those, maybe even all of them, but highlighting a couple that we have talked about in the past. I'm going to go to some oral arguments of just this past week. Some major cases involving the First Amendment and social media and the connection between government and social media, a big theme this year of the Supreme Court, in addition, of course, to the Trump cases and the violence cases involving guns and other issues also pending before the Supreme Court. This morning, we're going to talk about two major oral arguments of early this past week having to do with the intersection of social media and the government and the First Amendment. And then necessarily we're going to talk about that major immigration back and forth this past week, having to do with that Texas law. What did the Supreme Court do? What did the Fifth Circuit Court of Appeals do after the Supreme Court acted this past week? And provide you with just a little bit more, a brief update on our in-depth review of what Scott McAfee did last week. What did he do this present week, just this past week, in connection with the decision finding there was no conflict of interest by the prosecutor there in that Georgia case, but finding nonetheless an appearance of impropriety, directing basically that the principal lead prosecutor get off the case. Scott McAfee, the judge, did something else this week that also has an impact upon that decision of last week. A lot to get to this morning, a lot on our ambitious agenda, and we're going to launch into it right now on this, our newly styled, our newly reimagined show, Amicus, a law review. So let's begin by talking about the United States Supreme Court. Believe it or not, the Supreme Court has a 12-month term, and we're halfway through that at the end of March, even though that's a bit deceptive. Why? Because most of their decisions come out, as you know well, in May, June, sometimes as late as July. So we're expecting that probably 9 months into their term, at the end of June, end of July, most of the cases presently pending before the Supreme Court will be decided by then. The Supreme Court remains in action, remains active during those summer months as well, before the start of the new term again in October of this year, October 1 of 2024. Right now, 62 cases pending before the Supreme Court. When we come back, I'm going to tell you more about those cases, other things happening before our United States Supreme Court.
Your home for the Devil's Advocates. Weekday afternoons from 4 until 6 on The Shaw, 540 AM and 101.1 FM, WAUK.
CBS News Brief. ISIS claims responsibility for a mass shooting at a rock concert venue in Moscow. At least 115 are dead, over 140 injured. CBS's Sam Vinograd.
We don't know if there are other related plots underway that have to be disrupted.
The government will stay open after a $1.2 trillion bipartisan spending bill was passed in the overnight hours. Senate Majority Leader Chuck Schumer.
It's no small feat to get a package like this done in divided government. These past few months have shown yet again that when bipartisan has room to work, we can get the job done.
The Princess of Wales has cancer. Kate Middleton told the world her diagnosis yesterday, saying they discovered it when she was in the hospital for abdominal surgery.
At the time, it was thought that my condition was non-cancerous. The surgery was successful. However, tests after the operation found cancer had been present.
CBS News Brief. I'm Stacey Lynn.
This is your hometown radio, refreshed, keeping you informed, entertained, and connected locally across the Civic Media Network.
Wisconsin goes one and done. I'm Mike Clemens with sports. March Madness, the Wisconsin Badgers eliminated from the NCAA tournament. Too many missed shots, too many turnovers. They lose to James Madison University, 72-61. The Badgers season over with a record of 22-14. Marquette with a win over Western Kentucky, 87-69. They'll face Colorado on Sunday. Golden Eagles head coach Shaka Smart.
I thought Western Kentucky played with phenomenal aggressiveness in the first half. Hats off to their team, the way that they competed and battled. Fortunately, Tyler and Cam kept us afloat. We were fortunate to only be down 7 at the half. So just grateful for the response. We talk about building championship habits. One of the most important of those is the way we respond to adversity. And the guys did a great job of that today.
Hockey, the Wisconsin Badgers women's team beat Colgate 3-1. They'll advance to the finals against Ohio State on Sunday. With sports, I'm Mike Clemens.
With your forecast, I'm Corey Hartman. For today, sunshine and a high near 34. Tonight, mostly cloudy, lows around 25. Chance of rain and snow for Sunday with a high near 40 degrees and the winds pick up a little bit. Windy Sunday night and a chance of rain and snow, a low around 36. All rain Monday, highs in the 50s.
It's 21 right now.
The Maggie Dawn Show.
These 2 referendum that you will see on your April 2nd ballot. What is it that Republicans are after here? You cut funding for local elections. You restrict the hours. You restrict early voting. You intimidate and scare election workers so droves of them are quitting. I wonder where all of this is heading.
The Maggie Dawn Show. Weekdays from 2 till 4 on your local Civic Media radio station and on the Civic Media app.
As you age, you may have questions about finding transportation, healthy meals, or other services around your home and in your community. And the Elder Care Locator has the answers at 1-800-677-1116. Our caring advisors can connect you to trustworthy local experts and the support you need to age well at home. Real people, real assistance, and real connections are just a phone call away with the Elder Care Locator. 1-800-677-1116.
The Todd Alba Show.
I love me some Drew Holiday. My favorite Buck. I love what he's doing. I just really, really wish it wasn't for the Boston Celtics. My loyalty is still more to Giannis. But when Drew scores a bucket still, I'm like, yeah.
Like to a former lover.
I got a Drew Holiday jersey, a Bucks jersey, and I got an Aaron Jones Packers jersey. So I'm a scoring former lover for both of those players.
The Todd Alba Show. Weekdays noon till 2 on your local Civic Media radio station and on the app.
We've all felt left out. And for people who move to this country, that feeling lasts more than a moment.
30 seconds out.
We can change that. Learn how at belongingbeginswithus.org. Brought to you by the Ad Council.
Up North News Radio with Pat Kreitlow, Wisconsin's home for daily conversations about the state's latest headlines and stories. Weekday mornings from 6 till 8 on your local Civic Media radio station and on the Civic Media app.
Keeping Southeast Wisconsin informed, engaged, and entertained. This is The Shaw. 540 a.m.
We are back on our Saturday morning broadcast. Thank you for joining me and Anya. We're in the studios of WAUK in downtown Waukesha, but broadcasting to places throughout the state of Wisconsin. Delighted to have you with me this hour, hopefully next hour as well. This is our inaugural program under our newly styled name, Amicus, a law review. Talking a lot this morning about where that name comes from, friend of the court, but also offering information, expertise, insight that may have some bearing on the issues before us. That's also our mission here, not only in the courts of America, but also on this broadcast station, to spend some time talking with you about the major stories in the area of law and government, aspiration for justice mean, providing that additional perspective that may not come from the straight news stories. That's our mission here in this program. And consistent with that, spending some time, virtually all of our time this morning, talking once again about the United States Supreme Court. Halfway through its term at the end of this month. Again, a new term, the 2024-2025 term, begins on October 1 of this year. But right now, the Supreme Court has before it some 62
62 different cases. In each one of those, the court has said, yes, we will take a look at the lower court decision. They granted what is called a writ of certiorari. That is this, once again, Latin phrase that means basically, lower court, send me the material, send me the stuff that you have assembled during the course of the lower court trial so that we can take a look at whether you have done this right, whether this is proper, consistent with the law, the Constitution, and fundamental principles of justice. And so those cases come from a number of different sources, of course, and those include principally, not exclusively, but principally the various appeals courts, the federal appeals courts around the country. Among that 62, 11 of the cases come from the Ninth Circuit alone. That's the major circuit on the west portion of the continental United States of America, and also including Alaska and Hawaii. 11 cases from the Ninth Circuit alone, 10 cases from the Fifth Circuit. Again, significant. We talk a lot about the Fifth Circuit on this broadcast. Why? Because they're doing a lot of things, including some things we're going to talk about this morning that draw the attention not only of Americans, but also the courts from throughout our nation, including the United States Supreme Court. 10 cases pending from the Fifth Circuit Court of Appeals. Only two from our own Seventh Circuit, which again is Wisconsin, Indiana, and Illinois. Only 2 of those cases coming from our own Seventh Circuit. Of course, as you know, a lot of time that we see the Supreme Court in action, it is in these oral arguments, the times after the briefs have been filed, including the amicus briefs that are sometimes filed, the briefs of the petitioners, the respondents, all the writing has been done by the lawyers, all of that submitted to the judges, the justices of the Supreme Court, and they then have these oral arguments, which you can listen to. You can listen to live. You can also go on the Supreme Court website and pull those down and listen to them in a recorded fashion. John Roberts has made that available to all of us. You can listen to those oral arguments live. You can hear what the justices sound like. You can hear about the conversations between the petitioners, the respondents, and the justices, sometimes even arguing among themselves about what should happen, asking questions, making points. We're going to get to some of that today as a part of our examination of at least 1 or 2 cases. Up to now, in this present 2023-2024 term, the Supreme Court has conducted 20 of those oral arguments in the fall of last year, 26 to date in 2024 alone, even since January 1. So altogether, 46 up to this time. 15 more of those oral arguments are yet scheduled in March and April. And then at the end of April, Supreme Court is pretty much done with those oral arguments. So you can always go back in line and hear those oral arguments, pretty much done at the end of April. They have scheduled 15 more cases. And yes, indeed, as you know, those cases include 2 that we've spoken about at great length on this broadcast. On April 16th, this Fisher case that has to do with whether or not the statute under which Mr. Fisher, who's one of the people who was convicted for his assault upon the Capitol on January 6th, whether his conviction should stand based upon the nature and the content of the federal statute under which he was charged. The reason why that case is so important is because not only, of course, does it impact Mr. Fisher's status, but it's also the case under which many other of the other prosecutions were brought. That is, about 120 or so other defendants were also charged under the same statute. And there's yet another defendant out there. His name is Donald Trump. And he was also charged under the same statute, different set of facts, different kind of so-called talking indictment. That one brought, again, by Jack Smith, the U.S. Department of Justice. That case right now suspended while the Supreme Court does what? Well, here's a case on immunity. And the Fisher case, again, for oral argument on the 16th of April, Supreme Court going to decide ultimately, probably in June, whether that statute can in fact be applied to Mr. Fisher, to those 100 or so other defendants also charged and convicted, and perhaps even Donald Trump in his criminal prosecution in the Federal District Court in the District of Columbia. Much related to that, already suggested by me, is that on the 25th of April, about a week or so later, the very last day of oral argument before the Supreme Court, the Supreme Court hearing Trump versus United States. And yes, that is the immunity case. This is the case in which Donald Trump, through his attorneys, petitioning to the court, asking the court to find, as a matter of law, under these facts, but more generally, that presidents have immunity for their conduct, their criminal conduct while they're in the White House. A ridiculous proposition from the perspectives of many of us, including me, a frivolous argument. Nonetheless, the Supreme Court taking this up, already the subject of a lower court opinion from Judge Tanya Chutkan finding, nope, we do not have kings in America. We've got presidents who are, in fact, subject to law, not immune. The Court of Appeals for the District of Columbia coming to the same conclusion in an equally magnanimous and really sweeping order, finding the same. And Supreme Court now taking that up, further postponing the prosecution of Donald Trump while all of this is underway. That immunity argument scheduled before the Supreme Court on April 25th, coming up in just about a month from now. That is the last oral argument the Supreme Court's going to be taking up in this term. And then we wait until probably late May, in June, and perhaps even in July for the Supreme Court to come up and issue the remaining decisions. And it's got a lot of them that it has yet to offer. We know already that the Supreme Court has decided, believe it or not, among that 62 cases pending, among those that are scheduled for oral argument, it's already decided 11 of those. 11 of those already decided. So, for example, among those kinds of cases, as early as December 5th, the Supreme Court decided a case called Atchison versus Laufer, had to do with the ADA, basically said there's no standing there, had the case reversed, if you will, sent back to the lower court based upon mootness, a mootness issue there, but potentially raised an Americans with Disability Act issue. Support, the court did not get to that. A major case argued on February 8th called Murray versus UBS Securities, having to do with whistleblower status. On that same date, February 8th, the Supreme Court, in a case called Rural Housing versus Kurtz, heard oral arguments on a case involving the Fair Credit Reporting Act. A couple weeks later, on February 21st, a couple of additional important oral arguments, decisions rather, that the Supreme Court issued. One of them called McElrath versus Georgia, a double jeopardy case, sending the case back down to Georgia based upon a double jeopardy decision by the Supreme Court. And also on that same day, February 21st, a case called Raiders Retreat versus Great Lakes, having to do with maritime law. That case also decided on the 21st of February. A few more also among the 11 or so decided to this time. March 15th was another big day. Pulsifer, a major case, Pulsifer versus the United States, having to do with sentencing, federal sentencing in our trial courts, having to do with minimum mandatories and safety valves. On that same day, March 15th, also two major cases, Linke and Gardner, social media cases. We're going to review those in just a moment or so as we get back into the entire social media docket right now on the Supreme Court's list. And of course, you recall well, this major case on March 4th. March 4th issued Trump versus Anderson. That's the Colorado case. We spent a lot of time talking about that case on this broadcast. The Supreme Court finding unanimously with respect to the judgment, but a lot of dissent about the extent to which the Supreme Court went beyond what some of the dissenters felt they needed to do in finding that, yes, indeed, Donald Trump is going to remain on the primary ballot in Colorado and presumably other states around the nation, including places like Maine and Illinois, and maybe some 30 other states that also were waiting for the decision. Donald Trump remains on the primary ballot because why? The Supreme Court says only the legislature, only the federal legislature can make that decision to remove him under the 14th Amendment. We've talked a lot about that. Trump versus Anderson case issued on March 4th. A couple other cases issued on the 19th, case called FBI versus Fickrey involving the no-fly list, and Wilkinson versus Garland also issued recently, having to do with agency determinations and things lawyers love, mixed questions of law and fact, all kinds of things the Supreme Court has already decided. 11 cases up to now. Again, has about 50 or so more to decide. Lots of activity coming up. Probably most of that a little bit in May. Probably most of that once again in June and July as the Supreme Court resolves all of these matters before it, including the oral arguments still coming up. We talked last time about these major social media cases, including specifically this case involving the interaction between government and social media. The Supreme Court on Friday of last week, the previous week, issued a pair of unanimous decisions on these two paired cases on a subject that has roiled the waters of all levels of government, having to do with what government can and cannot do. The question is, when do public officials, elected or unelected, when do they violate the First Amendment by blocking? Yes, that's right, blocking critics from their personal social media pages. And again, we talked about this a lot last week. Important to set the stage for important oral arguments the Supreme Court had just this past week in this same area. So let's go back and talk a little bit more about this case. Michigan and California, some outraged citizens sued public officials there who were blocking them from those personal media pages. In one case, two elected school board members in Colorado had blocked some persistently critical parents from their social media pages. And in Michigan, a local resident sued an unelected city manager for kind of doing the same thing. He was blocked from the officer's Facebook page, and of course, expressing quite different views when it comes to social media. The individual in Michigan maintaining that the city manager violated his right to speak by blocking him from responding to things that the city manager had said on his personal page about COVID-19 and other matters. The petitioner said Mr. Freed, that's the city manager, was putting out policy directives. He was issuing press statements. And this was the only place the information was being relayed to the community. Freed, of course, replied that simply wasn't true. He answered constituent questions and pointed to them to press releases and other sites for local information. But 80% of the posts, he said, on my personal feed, my personal basis for my personal social media account, those were family photos and pictures of my dog, he said. I thought for a moment that this page was public and that I didn't control it. I would never have posted photos of my little girls or my wife, he said. Well, the Supreme Court, in the end, as we know from last week's exposition, didn't decide who was right, but it said basically we're going to lay down some guidelines for the lower courts in assessing the facts as we go forward in determining, again, this relationship between government and private citizens. Writing for the court, Amy Coney Barrett said that a post that expressly invokes state authority to make an announcement not available elsewhere is official, and members of the public are entitled to make comments in response. But a post that merely repeats or shares otherwise available information is more likely personal. The owner of the page may well be able to block critical or unwelcome comments. Who provides this information about standards going forward. When we come back, we're going to talk about the implications of that in connection with a couple of Supreme Court oral arguments of just this past Monday in the area of social media, government, and all of us.
The Shaw, WAUK. Nightlight with Pete Schwaba.
This is National Let's Laugh Day. I think laughter is truly the best medicine. What makes you laugh the hardest? My family members, my kids are funny. My dad makes me laugh. My wife makes me laugh. Conrad makes me laugh. I think one of the most important things that we can do in life is laugh. Personally, comedy's gotten me through some very tough times. It's great therapy.
Nightlight with Pete Schwaba, weeknights 7 till 9 on your local Civic Media radio station and on the Civic Media app.
You know, I hope this is the best hour of your life. I'll tell you that. The Cripes Cast, folks.
My conversation with Taylor Kalmus, a.k.a. Dude Dad.
When you go to the movies and you get to the last climactic scene, you're not just like, oh, you know what would be fun? Let's leave. Let's finish this movie in the parking lot. You guys don't know what I'm talking about, do you?
I think he's talking about...
Let's pull out of this movie theater.
Cripes Cast every Saturday and Sunday at noon across Civic Media and on the Civic Media app.
You're listening to The Shaw, WAUK, Waukesha's home.
We are back on this, the final segment of our first hour here on our newly styled Saturday morning broadcast named Amicus, a law review. We're talking about some Supreme Court oral arguments, specifically in the area of social media, the interaction between residents of our state, our nation, and government. What, in fact, can public officials do, elected or unelected officials do, when it comes to blocking individuals on their personal accounts that may, in fact, have information of a public interest? And so Amy Coney Barrett, in a couple of cases, again, Linkey versus Freed and O'Connor Ratcliffe versus Garnier, last week said the distinction between private conduct and state action turns on substance, not labels, she said. Private parties can act with the authority of the state, and state officials have private lives and their own constitutional rights. Categorizing conduct, therefore, can require a closer look. And again, establishing some standards, not deciding these two cases coming out of California and Michigan, but sending them back with some new standards for the lower courts to apply in determining whether or not the particular state officials, the government officials, had violated the First Amendment rights of residents who feel that by virtue of the postings on these social media posts, these accounts, they are no longer permitted to see things in the public domain, a violation of their First Amendment. So we'll continue to monitor those cases as they go forward. Among the 11 cases, the Supreme Court has already decided. Other cases, however, in the social media realm, not yet decided, and that includes two major social media cases before the Supreme Court just this past week. Let's talk about one of them. The first one called Murthy versus Missouri. And yes, indeed, during the course of the oral arguments, again, these times when the petitioners, the respondents, the parties have this chance to talk with the court members, hear questions from them, comments, respond to the concerns that the Supreme Court justices have. During the course of them, references were made between the two cases. One of them, again, Murthy versus Missouri. The other one, NRA versus Vullo, V-U-L-L-O. We're going to talk about those at the end of this first hour, the beginning of our second hour here on Amicus, a law review. A majority of the justices appeared convinced on Monday of just this past week, ultimate rule here, if you will, that government officials should be able to try to persuade private companies. They should be given that authority, whether news organizations or tech platforms, social media providers. Government officials should be able to try to persuade them not to publish information so long as the requests are not backed by coercive threats, so long as there's no threatening behavior going on. That appears to be where the Supreme Court is coming down on this major issue. A majority of the Supreme Court seemed wary on Monday at this oral argument of this bid by these two states, again, Missouri and Louisiana, to limit what the Biden administration, its interactions with some social media companies. Several justices questioning the state's legal theories and factual assertions. Most of the justices across the board, if you will, appeared convinced that government officials should be able to try to persuade private companies, again, anyone who's providing a social media platform, news organizations, tech platforms, those kinds of entities, not to publish information so long as those requests are not backed by some coercive threats. The dispute, of course, is the latest in the series of cases that we've talked about in this area of social media. Justices Brett Kavanaugh and Elena Kagan, both former White House lawyers, bringing that past experience to the oral argument just on Monday, said that interactions between administration officials and news outlets provided, as they described this, a valuable analogy. Efforts by officials to influence coverage, they said, are a part of valuable dialogue that is not prohibited by the First Amendment. So you've got at least two justices there, presumably weighing in, saying, states, you're wrong about this. Some members of the court during the course of the oral argument on Monday also raised some questions about whether the plaintiffs, Missouri and Louisiana, and about 5 other individuals along for the ride here, had suffered the kind of injury that permitted them to establish standing. Remember that concept? Got to be able to show that you've suffered some damage, some injury specifically. Wondered whether or not Missouri and Louisiana are really damaged themselves by this. They also suggest along the way that some broad injunction, some stopping, prohibiting contacts between government officials and the platforms was not a proper remedy in any event. So, for example, Justice Kagan said this to Louisiana's attorney, the Solicitor General from that state. She said,
I don't see a single item in your brief that would satisfy our normal tests, she said. Justice Sonia Sotomayor accused the states of distorting the record. In this case, she said this: I have such a problem with your brief, she said. You omit information that changes the context of some of your claims. That's not good language to be hearing from a Supreme Court justice when you're appearing in front of them, especially Sonia Sotomayor, who does not mince words. She said, you attribute things to people who it didn't happen to. Not a good day for the Solicitor General. They also peppered him with hypothetical questions about national security, doxing of public officials, contexts that would perhaps endanger teenagers, all suggesting that there is in fact a role for vigorous efforts by the government officials, again elected, appointed, to combat harmful speech. Only Sam Alito, perhaps not too surprising, a member of the court, who appeared most sympathetic, if you will, although even he wasn't vigorous in that, to the state's position. He said, whatever coercion means, whatever happened here is sufficient. The case, of course, arose, as I indicated, from this barrage of communications from the Biden administration, urging some social media platforms to take down posts on topics like the coronavirus vaccines, indicating that they're not effective, or providing other information suggesting that some remedies are in fact effective when they're not. Claims of election fraud as well. Members of the Biden administration reaching out to some of the platform providers saying that's simply not true. The 2020 election was not stolen. And last year, a federal appeals court severely limited those interactions. The Supreme Court had put that injunction, that stop, on hold while it considered the administration's appeal, and this, of course, followed. Justice Alito, during the course of this oral argument on Monday, said that the volume and the intensity of the contacts between the Biden administration and social media providers was troubling, and the suggestion there was that some of them, based with this government intrusion, were partners in an effort to combat misinformation about the pandemic, establishing a partnership that is not appropriate under the First Amendment. Under this onslaught, he said, the platforms routinely cave behind closed doors. The government badgers the platforms 24/7. So again, Justice Alito not supporting what the Biden administration was doing, but most of the other justices doing just that. When we come back in our second hour, more about this all-important case, reading the tea leaves from the oral argument of the United States Supreme Court of just this past Monday. Stay with us in our second hour, coming up after this break.
Show weekday mornings from 8 till 10 on The Shaw, 540 AM and 101.1 FM WAUK.
This message is for Shauna, my mom, who just finished her high school diploma. I wanted to say I'm so proud of you for finishing school. You taught me it's never too late to achieve your dreams. I hope to make you as proud as you have made me.
When you graduate, they graduate. Finish your high school diploma for you and for them. Visit finishyourdiploma.org to find free and supportive adult education centers near you. Brought to you by the Dollar General Literacy Foundation and the Ad Council.
You are listening to The Shaw, WAUK 540 AM Jackson, W266DR Waukesha, and always streaming on the Civic Media app.
This is CBS News on the Hour, sponsored by O'Reilly Auto Parts.
I'm Stacey Lynn. New details about a mass shooting at a Russian concert venue. Former CBS News Moscow bureau chief Beth Noble.
Russian President Vladimir Putin gave a video address to the nation in which he said that 11 people have been detained, including 4 who were the shooters at the Crocus City concert hall. President Putin said the perpetrators were detained as they were heading for Ukraine, where a window in the border had been opened for them to leave Russia. It's rather predictable that the Russians would try to pin this on Ukraine, but there simply isn't any evidence at this point that that's true.
At least 115 were killed in the attack, more than 140 injured. A delegation from Israel is heading to Washington this week, where U.S. officials will push them to hold off on a ground operation in Rafah. Details from CBS News national security contributor Samantha Vinograd.
We're in a race against time in Gaza, a race to save hostages, a race to save innocent civilians, and a race to prevent Israel from doing something that could damage its security over the long term.
The vice president is in Parkland, Florida today, where she'll meet with loved ones of those killed in a massacre at Marjorie Stoneman Douglas High School 6 years ago.
While visiting the school, the vice president will announce the Biden administration is launching a national extreme risk protection order resource center to help states with training and implementation of their local red flag laws. The administration is also urging states to use the $750 million in federal funding available for state crisis intervention programs. The White House says currently only 6 of the 21 states with red flag laws are accessing that funding. Natalie Brand, CBS News, Washington.
A sigh of relief for government workers. Congress passed a bipartisan spending bill around 2 a.m. this morning that will keep the business running and funded for the rest of the year. President Biden will sign it today. Well, following weeks of speculation about her health, Kate Middleton announced yesterday she has cancer. CBS's Charlie D'Agata is outside Buckingham Palace.
She always ranks as one of the most popular royals. So I guarantee you, over the course of the next few days, the next few weeks, everybody will turn from what is the palace trying to hide to is Kate going to be okay?
All right, here were the numbers.
Our first winning number tonight is 3. That's followed by 8. Up next, we have 44.
But no one hit them all. And so the Mega Millions jackpot swells to over $1 billion, $1.1 billion to be exact. There have been 30 drawings without a win. The next drawing is Tuesday night. Tonight could be your lucky Powerball night, too. That jackpot has reached $750 million. This is CBS News.
Think O'Reilly Auto Parts for all your car care needs. Get the parts and service you need fast from the professional parts people at O'Reilly Auto Parts.
You can always continue the conversation on social media. Share your thoughts when you find and follow Civic Media on Facebook, X, and Instagram.
For Civic Media News, I'm Terry Bell. More young Americans are getting colorectal cancer. Doctors are urging people to get screened earlier. Eric Tegedoff reports.
March is Colorectal Cancer Awareness Month. Colorectal cancer is the third most common form of cancer and the second most lethal form in the world. Dr. Margaret Chen with Kaiser Permanente says the number of younger Americans with advanced stages of colorectal cancer has gone up in recent decades, prompting the U.S. Preventive Service Task Force to lower its recommended screening age from 50 to 45.
This is surprising to a lot of us, but the statistics have shown this change from what we used to think is a disease for older people to now a disease for younger people.
Chin says the proportion of cases for people under 55 has nearly doubled over the last 25 years. However, she also notes the total number of colorectal cancer cases has actually declined, and that's likely due to better detection. Chin says there are options for how people can get screened. The traditional method is by colonoscopy, but a newer method is the Fit Kit test, which can be used at home. Chin says it's important to find the option that works best for each person.
The best screening test is the one that you will do. So I just want to encourage people that we cannot find cancer if we're not looking for it. So please talk to your provider about getting screened as soon as you can.
Colonoscopies are typically done every 10 years, while the FIT tests are taken every year. With FIT kits, doctors look for microscopic blood and stool samples. I'm Eric Tegedoff. Find our trust indicators at publicnewsservice.org.
You're listening to Civic Media News. I'm Terry Bell.
One minute out.
With your forecast, I'm Corey Hartman. For today, sunshine and a high near 34. Tonight, mostly cloudy, lows around 25. Chance of rain and snow for Sunday with a high near 40 degrees and the winds pick up a little bit. Windy Sunday night and a chance of rain and snow, a low around 36. All rain Monday, highs in the 50s.
It's 24 right now.
Waukesha, home of Les Paul, our awesome farmers market, and The Shaw, 540 AM and 101.1 FM. Good morning, and welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
Good morning. It is Saturday, March 23rd, 2024. This is the second hour of our newly constituted, our newly restyled, our newly imagined Saturday morning broadcast, but staying with you on all those major issues in the area of law, government, courts, and the aspiration for justice in America and around the globe. Delighted to have you with me once again. I'm here in the studios of WAUK, the Civic Media Studios here in downtown Waukesha, with my wonderful producer, Anya, and together we're presenting to you once again, as we have done in 89 previous broadcasts, information, insight, in our role as Amicus, thus the name of the show, Amicus, a law review. Amicus, as I said in great detail at the start of the first hour, this notion coming from the legal Latin, and the fundamental notion there that an amicus is someone who's a friend of the court, who provides and offers to the court some information, some expertise, some insight that may not otherwise be readily apparent to the court, to the litigants, to the parties to the case, but nonetheless is important to understanding and appreciating civics, understanding the law, understanding the facts, understanding what is going on in our world. And so most appropriate that we here at Civic Media would adopt that as our new moniker, our new name for this Saturday morning broadcast, much the same content, and as always, spending a lot of that talking about courts and the roles that they play in our lives. Delighted to have you with me once again this morning and every Saturday morning on the broadcast stations of Civic Media. As we concluded our first hour on this Saturday morning broadcast, we're talking about this major case before the Supreme Court on Monday of this past week called Murthy versus Missouri, M-U-R-T-H-Y, an oral argument, again, not a decision yet, an oral argument before the Supreme Court brought by the state of Missouri and the state of Louisiana, challenging decisions and actions undertaken by the Biden administration, reaching out to social media platform providers, asking them to take down, for example, misinformation about the elections, and indicating that the 2020 election may have been stolen. There was a product of fraud. Also encouraging those social media platform providers to prevent the postings and take down information suggesting that the coronavirus is in fact susceptible to remedies through untested and frankly dangerous medicinal applications, suggesting also that vaccines would not be significant in reducing your exposure. All those kinds of things, a part of the administration's effort to reach out and successfully reach out to these platform providers and say, you know what, that's not accurate. That is misleading. Take this down. It is not in the best interests of America, and frankly can be just downright dangerous, including to young people. And of course, along the way, what happened is the Fifth Circuit Court of Appeals, again, hearing these cases from the two states, initially determines that indeed the administration has gone too far and finds, of course, during the course of their own deliberation, that the officials from the Biden administration had become much too excessively entangled with the platforms and the staff there, or used threats to spur them to act. The panel of the Fifth Circuit entered an injunction basically stopping, forbidding these officials from, as they said, coercing or significantly encouraging social media companies to remove content protected by the First Amendment. The case comes up from the Fifth Circuit. Among those cases we described before, among the 10 right now pending before the Supreme Court, plainly gets some sympathetic hearing from the voices of folks like Justice Alito, Justice Gorsuch, and also others on the bench, including Clarence Thomas. But we also get some very interesting exchanges between
other members of the Supreme Court, suggesting that there's nothing wrong with what the administration did. We've got Justice Kavanaugh, for example. He served in the White House, as you know, for the administration of George W. Bush. He said it was probably not uncommon for government officials to protest an upcoming story on surveillance or detention policy and say, if you run that, it's going to harm the war effort and puts Americans at risk. Plainly, thinking back to his own time before he was a Supreme Court justice to the time that he was a lawyer in the President George Bush administration. That was perfectly proper, Kavanaugh says, adding it would be a different matter if the requests were backed by a threat of some certain kind of action, including some antitrust action, okay? Justice Kavanaugh said he understood, based upon earlier government service, that there are experienced government press people throughout the federal government who regularly call up the media and berate them. And Justice Kagan echoed that very point. She said this, she said, like Justice Kavanaugh, I've had some experience encouraging the press to suppress their own speech. She sketched out some of those specific conversations again from her time in the administration, in the executive branch. She said, you just wrote a bad editorial. Here are 5 reasons you shouldn't write another one. You just write a story that's filled with factual errors. Here are the 10 reasons why you shouldn't do that again. Again, probably recalling perhaps her own engagement with the media when she was doing exactly what is being challenged here in this case. She wanted to say this. She said, this happens literally thousands of times a day in the federal government. And again, in the category of some jocularity, Chief Justice John Roberts, another former White House lawyer on the Supreme Court today, registered kind of a lighthearted dissent to laughter in the courtroom. He said this, I have no experience coercing anybody. He said, I want to make that clear. But he also goes on to add, the government is not monolithic and that different parts of it may hold and press competing views. Again, Justice Alito, who, as you well know, has been the subject of a lot of critical news coverage, kind of joined in this somewhat lighthearted exchange, kind of taken up with the idea of pushing back against this. He's wondering out loud whether the court's public information officer was in the courtroom during the course of this particular oral argument. He said this, maybe she, then making reference again to the public information officer, should take a note about this, he said, so whenever they write something that we or I don't like, she can call them up and curse them out and say, why don't we be partners? We're on the same team. So a little bit of lightheartedness in the midst of this very serious discussion appears from the majority, not everybody in the Supreme Court, that in this case was called Murphy versus Missouri. The Supreme Court's going to overturn the Fifth Circuit and permit this administration and presumably future administrations, executive branch officials to engage in this kind of conversation with social media providers, other tech companies, even news organizations, using the language that Elena Kagan described here, that she used apparently, that Justice Kavanaugh used when he was in the White House, all those kinds of things to say, hey, knock it off, take this down, as long as there's nothing coercive about it. As long as you're not threatening things like legal action, threatening other conduct that could affect the very operation of that entity. As long as there's no coercion, it appears that that's going to be the linchpin for the Supreme Court in making this decision. Once again, Murphy versus Missouri, among these major social media cases, it has taken up this year, defining the relationship between government and social media, the things that we see all the time on social media platforms. Murphy versus Missouri. We'll look forward to reporting on that to you and commenting on it. You can determine whether or not my prediction about the likely result here is true or not when that decision comes out again, presumably May or June, maybe even July, as the Supreme Court addresses all of these cases. On the same day that it took up Murphy versus Missouri, the Supreme Court took up another case called NRA versus Vullo, VULLO, another social media case, also among the 62 cases before the Supreme Court. What is this case all about? The National Rifle Association, the NRA, had argued that a New York official violated the First Amendment by encouraging some entities with whom she had a professional relationship in her role as a regulator to break ties with the NRA after the Parkland mass shooting in Florida. Now, what do we know about what happened here? What tea leaves can we read from this related but different case oral argument also happening on Monday? Again, some references made back and forth between the two cases, even though they involve different issues and different parties. A majority of the Supreme Court on Monday appeared to embrace arguments by the National Rifle Association that this New York State official had in fact violated the First Amendment by trying to dissuade some of these companies from doing business with it after that deadly school shooting in South Florida. The dispute, of course, began after a gunman, as we all recall with horror. 2018, Marjorie Stoneman Douglas High School, Parkland, Florida. One of two cases on Monday, the other one, of course, being this Murphy versus Missouri case that involved government advocacy crossing the line or not crossing the line, involving the protections of free speech. After the shooting, of course, we recall this well, catastrophically killing 17 students and staff members. This particular New York official, her name is Maria Vullo, V-U-L-L-O. She was then a superintendent of the New York State Department of Financial Services. She said that banks and other insurance companies regulated by her agency should assess whether they wanted to continue providing services to the NRA. She reached out to them and made that encouragement, if you will. The gun rights group sued, of course, accusing Vullo of unlawfully leveraging her authority as a government official, trying to do something that her authority did not permit her to do. It was a campaign by the state's highest political officials to use their power to coerce a boycott of a political advocacy organization because they disagreed with its advocacy. That was the statement argued and presented by the legal director for the ACLU, who is arguing on behalf of the NRA during the course of the oral argument. He added the officials' actions had cost the group millions of dollars. The lawyer for the New York officials, again, his name is Neil Katyal. You may see him on the news a lot. He was also a former acting solicitor general, the person who previously would present the government's positions before the Supreme Court. He pushed back on that. He said that state officials were simply performing their ordinary duties. We think, he said, that it was an exercise of legitimate law enforcement authority. And the Solicitor General herself, Elizabeth Prelogar, who's in a friend of the court brief, an amicus brief that she had filed with the Supreme Court, describes some of the NRA's claims as plausible, namely that Vullo may have crossed the constitutional line by coercing regulated entities to terminate their business relationships. When we come back, we're going to talk more about how the members of the Supreme Court responded to those oral arguments before it, in this case, NRA versus Vullo. Stay with us for that exposition.
This is the Shaw WAUK.
Are record energy costs putting a squeeze on your fixed or limited incomes? With inflation rising at record levels and incomes not keeping pace, you might be one of tens of thousands of Wisconsin residents who are struggling to survive in the blistering heat of summer or the bitter cold of winter. While you haven't asked for it, the Keep Wisconsin Warm Cool Fund and your local energy assistance providers are here to help. No Wisconsin resident should ever have to face the challenge of living without heat or power or face homelessness. For a hand up, apply today and call 1-800-506-5596. That's 800-506-5596. Or visit www.heat.help.
You're listening to the Shaw WAUK, Waukesha's home for the Devil's Advocates radio show.
We are back. Our Saturday morning broadcast, talking with you this morning about these significant oral arguments happening just this past week, early in the day on Monday, talking about social media, responses by our Supreme Court justices to the interaction between social media and government and platform providers. What can we understand about the First Amendment? This case, NRA versus VULO, National Rifle Association, arguing that this New York State official had crossed the line, had violated the First Amendment by encouraging entities that she was regulating to break ties with the group based upon their advocacy. Arguments for the Supreme Court on Monday. During that oral argument, an assistant to the Solicitor General drew a distinction between this NRA case and the other case we talked about, this Murphy versus Missouri case, heard earlier that day. And that, of course, by these states to try to curb the Biden administration, rather, from its efforts to crack down on what it viewed as misinformation in social media. The Murphy versus Missouri case, and again, describing the differences between that case and this one. Like the Murphy case, the NRA argument centered on the line between coercion and persuasion by government officials. It seems to be where the Supreme Court in these two cases is coming down. Out and out coercion, obviously not appropriate. Persuasion, maybe so. And where to draw the line appeared to be front and centered for most, if not all, of the Supreme Court justices. The Supreme Court Chief Justice says this: there's considerable overlap, obviously, he said, with the first case, again, making reference to Murphy, even during the course of the oral argument on the VULO case. Could you articulate, he said to the attorneys appearing before him, what the significant differences are between your position in this case and the office's position, that is the Office of the Solicitor General here, in the prior case? And the Solicitor General said, there are no differences as to legal principles, basically saying, Justice, we are consistent in our view. The difference here is that there is a specific coercive threat in this particular case that did not exist in the Murphy case. And that seems to be where most of the justices are coming down in deciding this case. He was referring, of course, to this allegation the NRA had made that VULO had met privately with the organization's insurance partners, demanded that one of them, Lloyd's of London, stop providing insurance to gun groups, especially the NRA. And the attorney had argued that and urged the justices that to hinge the First Amendment analysis on the nature, the focus of that meeting, it's just a straightforward way of resolving this case, the attorney advocated. In other words, if you make this very fact specific and find that this particular engagement by VULO, coercive in nature, encouraging them, more than encouraging them, not to engage with the NRA, that's the line that you can draw. You can draw a specific rule of operation here that permits engagement, but not coercion. That's how the attorneys seem to be encouraging the Supreme Court to decide in the end. And after Brett Kavanaugh repeated to the attorney for New York that he understood the government to be arguing that the meeting itself is enough for a First Amendment violation, that attorney pushed back, contending that the New York officials were engaged in normal plea bargaining. And said this: if that meeting is enough, Justice Kavanaugh, every meeting, every plea negotiation is enough. That's literally what they are. They're done in secret behind a closed door, to use their insidious language. That's the natural give and take. Again, this is the lawyer for New York arguing that this is the normal practice. This is what has got to happen here. The NRA, of course, objecting to that, citing what it described as VULO's enormous regulatory power, adding that she'd applied pressure tactics, including back-channel threats, omnibus guidance letters, selective enforcement of regulatory infractions. The organization warned of the wide-ranging consequences of a ruling, things the Supreme Court's always concerned about. If we announce today a rule, how does this affect the next case down the road, the next social media case that we may hear in a future term, making similar pleas about other hot-button issues like abortion and the environment and commerce and education, all those other things out there down the road. All of this pending before the Supreme Court now. It appears the Supreme Court not dividing in this resolution of these two cases, but probably finding a First Amendment violation based upon coercion in the VULO case, but not a First Amendment violation in Murphy based upon persuasion and encouragement, and drawing that articulated legal line between the two of them. Fascinating stuff to think about
as we consider the role, once again, of government and the law and social media providers and where those lines are drawn. We know as well that there are still those other cases out there, we've talked about them before, in which a couple of states have also sought restrictions by the social media platform providers themselves when it comes to their uniformly taking down on their own initiative postings that are offensive, that are conveying misinformation, that are otherwise contrary to the best interests of the public. Laws out there passed by some state legislatures that prohibit the providers from taking those down. Highly unlikely in that particular case, as we have talked before, Supreme Court's going to embrace the legitimacy of those state laws that restrict that kind of activity by the providers, which in the end are private companies. Lots and lots of things to digest here, lots and lots of things to consume as the Supreme Court tells us more and more, probably in May, in June, maybe in July, about, once again, this relationship between social media and government and you and me. No discussion, of course, of the Supreme Court could not be included, could not be complete without including references to other things also going on in the terms of oral arguments. Just this past Tuesday, Supreme Court heard oral argument in a case involving expert testimony in a drug courier prosecution called Diaz versus United States. Another case called Truck Insurance versus Kaiser Gypsum, a Chapter 11 bankruptcy proceeding, giving you some sense about the diversity of the cases, those 62 cases pending before the Supreme Court on Wednesday this past week. In a case called Gonzalez versus Trevino, a case involving probable cause and retaliatory arrest claims in that case. Another case also argued on Wednesday, Texas versus New Mexico and Colorado. This has to do with the Rio Grande Compact and the decisions of a special master. Lots and lots of things before the Supreme Court also be decided in May, June, and maybe even in July. Also significant to note, of course, that there are 5 oral arguments coming up this coming week as well, including FDA versus Alliance for Hippocratic Medicine. What is that? That's that major mifepristone case coming out of the Northern District of Texas, in which the federal district court judge affirmed, basically, not completely, but affirmed by the Fifth Circuit, prohibiting access to mifepristone as a part of reproductive services, determining that the decision of the FDA to authorize the use of mifepristone as a safe and secure drug was arbitrary and capricious. That, among the cases Supreme Court also has before it, having to do with our agencies and administrative functions. That argument coming up this coming week, March 26th, major case. Once again, you can hear the oral argument on the mifepristone case, that coming up just this week. And departing briefly from the Supreme Court, of course, on Monday, the day before the mifepristone case, Judge Juan Merchan entertaining argument from attorneys in the prosecution in Manhattan. When we come back, I'm going to tell you more about that and then get back to more Supreme Court information for your information and also your guidance coming up this coming week.
Whether you're heading down Les Paul Parkway or fighting traffic on the interstates, this is The Shaw, 540 AM and 101.1 FM, WAUK.
CBS News Brief. Russian President Putin is vowing to punish those behind that concert massacre that has left at least 115 people dead. He's blaming Ukraine, which denies any involvement, even though ISIS has claimed responsibility. The BBC's Merlin Thomas is looking at video from the scene.
Witnesses said the shooting started inside the lobby. You can hear loud gunfire ringing out and see people crawling away on the floor.
Overnight, the Senate passed a $1.2 trillion spending package, averting worries over the partial government shutdown. Senate Majority Leader Chuck Schumer says it wasn't easy, but it is good for the nation. Some parts of the U.S. are going to need gloves and shovels or umbrellas this weekend.
Interior Northeast locations, upstate New York, much of interior New England expected to see widespread heavy snowfall.
That's Zach Taylor at the National Weather Service in Maryland. CBS News Brief. I'm Allison Keyes.
Enjoying this local program? Find the complete Civic Media lineup at civicmedia.us or the Civic Media app.
Wisconsin goes one and done. I'm Mike Clemens with sports. March Madness, the Wisconsin Badgers eliminated from the NCAA tournament. Too many missed shots, too many turnovers. They lose to James Madison University, 72-61. The Badgers season over with a record of 22-14. Marquette with a win over Western Kentucky, 87-69. They'll face Colorado on Sunday. Golden Eagles head coach Shaka Smart.
I thought Western Kentucky played with phenomenal aggressiveness in the first half. Hats off to their team, the way that they competed and battled. Fortunately, Tyler and Cam kept us afloat. We were fortunate to only be down 7 at the half. So just grateful for the response. We talk about building championship habits. One of the most important of those is the way we respond to adversity. And the guys did a great job of that today.
Hockey, the Wisconsin Badgers women's team beat Colgate 3-1. They'll advance to the finals against Ohio State on Sunday. With sports, I'm Mike Clemens.
With your forecast, I'm Corey Hartman. For today, sunshine and a high near 34. Tonight, mostly cloudy, lows around 25. Chance of rain and snow for Sunday with a high near 40 degrees and the winds pick up a little bit. Windy Sunday night and a chance of rain and snow, a low around 36. All rain Monday, highs in the 50s.
It's 24 right now.
Matt Nair on air.
The hearing surrounding the alleged Biden crime family didn't go very well for House Republicans. They got nothing.
They also have no way of moving this country forward. Every 45 days, we're on the brink of a shutdown because these idiots can't come together and put forth a budget. How about this? You don't get to try to impeach anybody until you finish your homework.
I would heartily back that.
Matt Nair on air. Weekdays 10 till noon on your local Civic Media radio station and on the app.
Don't you wish your life came with a warning app?
Stop. That dog does not want to be petted.
A heads up before something bad happens.
You should not send that text.
Uh-oh. Life doesn't always give you time to change the outcome, but prediabetes does. With early diagnosis and a few healthy changes, you can reverse prediabetes and prevent or delay type 2 diabetes. To learn your risk, take the 1-minute test today at doihaveprediabetes.org. Brought to you by the Ad Council and its prediabetes awareness partners.
The Devil's Advocates radio show.
I ate at gas stations today. You took me to the finer gas station.
You drove, dude. What are you talking about? You're a grown-ass man. Go get yourself a piece of cherry pie, man. What do you want me to do? Do I look like a roasted turkey to you right now? I know you're hungry. Like the cartoon style.
You do look like a
beef, a little piece of bacon, a slab of meat, something.
Oh, yeah.
The Devil's Advocates radio show. Weekday afternoons from 4 until 6 on your local Civic Media radio station and on the app.
We've all felt left out. And for people who move to this country, that feeling lasts more than a moment. We can change that. Learn how at belongingbeginswithus.org. Brought to you by the Ad Council.
Missed your favorite show live on air? It's easy to find what you enjoy wherever you listen to podcasts, including Spotify, Apple, and Google Podcasts. And we're always streaming on TuneIn and the Civic Media app.
Broadcasting to Waukesha at 101.1 FM. Broadcasting to Southeast Wisconsin at 540 AM.
Welcome back to Amicus, a law review. This morning, talking, as we often do here in our Saturday morning broadcast, all about the United States Supreme Court, talking about these major oral arguments of just this past week having to do with social media. The Supreme Court probably making decisions in the end premised upon the nature of the government interaction with social media providers. If it is coercive, if it is threatening, not permissible under the First Amendment. But if it is simply encouraging, it's got some legitimate purpose, that probably permissible. We'll see what the Supreme Court says in these two cases, Murphy versus Missouri and NRA versus Vulo, coming up in the next several months. Also talking about what's happening next week Lots of things going on in the area of rule of law and justice in our nation's courts. On Tuesday, March 26th, that same Supreme Court going to be hearing this case involving mifepristone. This is the FDA case coming out of Judge Kaczmarek's decision. Northern Texas finding that the FDA had improperly authorized the use of mifepristone for reproductive services, for abortion procedures, up to the Fifth Circuit, now on to the Supreme Court. That argument again, this coming up this coming Tuesday, along with 4 others among the 62 cases pending before the Supreme Court. The day before, as I was reporting, as we were calendaring right before the break, on March 25th, not in the Supreme Court, but in a trial court in Manhattan. Proceedings not in the nature of a trial, but the judge. This is the judge, Juan Merchan, who's presiding over the case involving Donald Trump, brought by the DA. His name is Alvin Bragg, against Donald Trump, alleging that he violated New York law in providing hush monies, catch and kill monies in connection with an attempt to silence at least one porn star, and coming forward with a story of an affair that she had with Donald Trump right prior to the 2016 election. All of that, one of the several criminal trials pending against Donald Trump right now, the one that probably still has the most likelihood of perhaps going to trial. We recall well that it was supposed to go to trial this coming Monday, March 25th, all anticipating the first time in our nation's history that a former president would be on trial, jury selection, a jury hearing evidence of criminal conduct in a criminal court in our nation against a former president. Did not happen. Why? Because a little over a week or so ago, it turns out that the U.S. Attorney's Office in the Southern District of New York, the Department of Justice, produced about 100,000 documents, additional documents, not previously a part of discovery, the production of materials to all the parties, including especially defense in this case. And as a result of that, Alvin Bragg saying, you know what? Under the rules, under the regulations, under fundamental justice, it is only right that Donald Trump and his attorneys get the opportunity to review all of this material we have not previously provided. And so Judge Merchan obliged under the law to postpone the trial beginning on Monday, but instead deciding to call everybody in. And he's going to do that on Monday morning, a very interesting, fascinating hearing, perhaps going to be available also live, certainly will be recorded. And Judge Merchan asking the all-important question, what is going on here? He asked the parties already to present to him in writing some memorandums about who said what to whom, who produced what when, under what circumstances, what did the subpoenas say, past and recent, how did this production go? He wants timelines. He's gotten that from them. And now, come Monday morning, he is going to be quizzing all the attorneys, including Alvin Bragg, including counsel for the defendant, Donald Trump, on what happened here. Why is it that my trial, he will say, that I had scheduled here in my court for many, many months has now got to be postponed at least for another month while we figure out what's happening with discovery? He is going to be asking lots and lots of questions about the conduct, the behavior of all the parties, including, I would offer, the U.S. Department of Justice in producing these materials to Alvin Bragg, to the defense, late in the game. We have known about this particular offense conduct for many years, shortly after the 2016 election, investigated by the Department of Justice. That's why they had these materials in the first place. Some of that material highly relevant. Why? Because it involves Michael Cohen. Michael Cohen, who again was the former president's fixer, his private attorney, if you will. Michael Cohen also now testifying in connection with this pending case in front of Judge Merchan. Highly relevant. Judge Merchan asking these questions and determining, presumably in the end, what he's going to do. Hopefully getting this case back on track after he gets the explanations that he is going to be soliciting, asking the attorneys to come back. He has said at least as early as April 15th, maybe even later than that, maybe into May, maybe into June, depending upon what the merits of this are all about. Donald Trump's attorney will certainly be arguing for an extended period of time. It is 100,000 documents. It does take some time to review them. Maybe not all of them have to be read in document form. A lot of this can be done electronically using search engines, but nonetheless, appropriate to provide the defense some opportunity to review all that.
What is the amount of time that needs to be taken to do that? What is the new trial date? We may have that. We may have that at the end of the day on Monday after the parties explain to Judge Merchan what it is that happened here. A big week next week coming up in the courts of America. We also know that something else significant happened this past week, not involving an ultimate case presented to the Supreme Court, but its administration of these continuing appeals having to do with immigration law. We know the Congress came fairly close not too long ago to passing a bipartisan omnibus immigration bill, fell apart, presumably upon the encouragement of presidential candidate Donald Trump. 2 Republicans inside the House of Representatives not to go ahead with it, to vote against the own bill, the bill that they themselves had put together. All of that pending in the area generally of immigration. At the same time, that Texas had passed this major law that threatened and called into question the authority of the federal government under that thing called the United States Constitution. The federal government, the exclusive authority when it comes to immigration. The Texas law, which had empowered local officials, state officials, to arrest and deport migrants who enter the country, presumably through the Texas border, without authorization. All of that law, of course, and other aspects of it, challenged by the Biden administration in the federal courts, saying you can't do that. That's contrary to the Constitution. Only the federal government, only federal agencies, only the executive branch is responsible for the administration of immigration law under our Constitution, cannot do this. Well, the Supreme Court on Tuesday temporarily sided with Texas in this increasingly bitter fight with the Biden administration over this immigration policy issue, allowing this very extensive law to go into effect that makes it a crime for migrants to enter Texas without authorization. And of course, typical with when the court acts on what's called emergency applications. Again, these are not the major cases, not among the 62, but emergency applications to the court to do something, to stop a law, which we've talked about before. The court giving no specific reasons for doing that, but Justice Amy Coney Barrett, joined by Brett Kavanaugh, filed a concurring opinion that sort of seemed to express the majority's bottom line. They were turning the case to the appeals court, and yes, indeed, that's the Fifth Circuit, for a prompt ruling on whether the law should be paused while an appeal moves forward. Following all of that, Justice Barrett wrote, if a decision does not issue soon, the applicants may return to this court. All of this has to do with the interplay between things that lawyers, once again, love to talk about, the difference between an administrative stay and a stay pending appeal. Justice Sotomayor, joined by Justice Jackson, others said the majority had rewarded the Court of Appeals in the Fifth Circuit for using this unseemly procedural gambit, is what she said. The appeals court had entered an administrative stay of a trial judge's ruling, effectively blocking the law and therefore compelling the majority in the Supreme Court to stop this law from going into effect. Well, that was chapter 1 on Tuesday. All that happening, that dissenting language coming out of some dissenters when it comes to this tension, if you will, between the stays, the administrative stay, and a stay pending appeal. Sure enough, the law goes temporarily into effect after that Supreme Court ruling. But hours later on Tuesday, that very appeals court that the Supreme Court made reference to unexpectedly issues an order effectively blocking the law's implementation, sending it back to where it was before. The state of Texas, again, late Tuesday, once again prevented from enforcing this strict new immigration law that gives these local police agencies the power, incredible power, to arrest migrants who cross the border without authorization. Fifth Circuit Court of Appeals, once again, before midnight on that day, caps a day of legal whiplash, some whiplash having to do that day, hours after the Supreme Court again allows the law to go into effect. A law, needless to say, and the ruling on this back and forth, creating a certain amount of confusion among the border, including law enforcement, outraging some immigration advocates, tending to show once again the problems in administration of immigration law when you don't have an omnibus bill in place. At issue, of course, is whether the law should be put on a long-term hold while the Biden administration claimed that the law is unconstitutional, makes its way through the legal system. The Fifth Circuit held that oral argument on Wednesday after this whipsaw engagement on Tuesday on whether the district court's injunction, the district court stopping this matter, that injunction should remain in place as the appeals court process goes forward. A lot to consume there. This is not intuitive. There's a lot going on here. Not clear what further action the court might take. But for the moment anyway, the law is again blocked. And consequences to that as well, as we know in the wake of that. Recall well the Supreme Court's decision on Tuesday, the follow-up on with the Fifth Circuit Court of Appeals also later that day, the Fifth Circuit hearing on Wednesday, allowing Texas on this law to first arrest and deport migrants and then for prohibiting them from doing just that, has resonance back to the situation in Arizona from about a decade ago, when you may recall the state of Arizona, the legislature there passed its own law as a sort of crackdown against illegal immigration more than a decade ago. The Arizona effort, you may remember, became known as the Show Me Your Papers law, passed by the Arizona legislature, set off an equal torrent, if you will, of anger, fear among not only migrants, but also advocates, jolted the state's political status in ways that are still reverberating. Supreme Court in that case saying, no, only the United States government. It's a federal matter. James Madison wrote about this in the Constitution. Arizona can't do that. Maybe offering a lesson to what the Supreme Court should do in its ultimate disposition of this case in Texas. Along the way, some other implications from the lack of certainty, this back and forth, this whipsaw in Texas. We know that on Tuesday, Iowa lawmakers passed a law that would make it a crime to enter the state after being deported or denied entry into the United States of America. They're taking on, once again, their own legislation. And that passage, of course, puts this Midwestern state on track to join Texas, doing the same thing, enforcing immigration, which again is exclusively inside the federal authority. Mexico, of course, which is supposed to be the recipient of any of these recently deported migrants coming out of the state of Texas. The law in Texas, this state law says we're going to return them to Mexico, regardless of their state of origin. Mexico says, nope, we're not accepting any deportations made by Texas under any circumstances. The country's foreign ministry said on Tuesday, in response to all of this going on, they condemned the state law known as Senate Bill 4, saying it would separate families, violate the human rights of migrants, and generate what Mexico called hostile environments for more than 10 million people of Mexican origin living in Texas. Plainly, Mexico is saying, we're not playing along with this law right now, stayed there in the state of Texas. Again, hearings coming up in the state of Texas. The Fifth Circuit going to decide ultimately, probably back to the Supreme Court, question whether it'll be this term or in a future term. Shades also of what the Supreme Court did in the Dobbs decision. The Dobbs decision, again, permitting a law there to go into effect on abortion even before deciding the Dobbs case. All of that coming out of federal appeals courts, the United States Supreme Court just this past week. More on all of this and the actions of our federal courts and state courts right after this break.
You're listening to The Shaw, WAUK.
Most of us can agree the decision to have an abortion should be between a person and their doctor. Politicians should have no say at all. Thankfully, Senator Tammy Baldwin is standing up for our rights and working to keep politicians out of our medical decisions. After Roe v. Wade, the court case that protected abortion rights was overturned, Tammy Baldwin introduced the Women's Health Protection Act, which would ensure access to abortion everywhere in the United States, including here in Wisconsin. The bill would end
song is
Extreme
2.5
abortion
minutes,
bans that
just
have
so you
no
know.
exceptions for rape, incest, or the life of the mother, and threaten doctors with criminal charges for providing abortion care. Senator Baldwin also introduced legislation that would protect the right to travel across state lines for reproductive health care and safeguard access to contraception. Call Senator Tammy Baldwin at 202-224-5653. Tell her thank you for fighting back against extreme abortion bans. Paid for by A Better Wisconsin Together, Inc.
The Shaw, WAUK. Welcome to Amicus, a law review. Good morning, and welcome to Amicus, a law review with Jim Santelle.
And we are back, and this is Amicus, a law review. This is our newly restyled, our reinvigorated, and our reimagined program here, as always, talking with you about law, justice, government, and the aspiration for justice in America, in our state of Wisconsin, and throughout the world. As a part of this, in this, our final segment, a couple of comments about something else that follows up on a story that we did in great detail, some microscopic justice of just last week. You may recall well that we spent a lot of time parsing through this major opinion issued by Judge Scott McAfee. He is the state court judge in Fulton County, Georgia. He's presiding over that omnibus RICO case in which Donald Trump and many others are charged with RICO violations, again, for attempting to undermine the voting process, the electoral process there in Georgia. The court entertaining during the course of 2.5 days of evidentiary hearings this petition by at least one of the defendants, joined in by 7 or 8 others, including Donald Trump, seeking to have Fani Willis, who's the DA in that case, disqualified based upon her personal relationship with a fellow named Nathan Wade, who is the lead prosecutor. These hearings, fairly salacious, talking about personal relationships, financial relationships between them. And in the end, Scott McAfee issuing this major decision the week before this past one, finding that there's no conflict of interest, that Fani Willis does not have to be taken off the case, but that there is an appearance of impropriety such that her lead prosecutor, Nathan Wade, needs to go. And that's indeed what he did shortly after the order was issued. Now, as I said in the previous broadcast, Fani Willis has 3 alternatives in the wake of all of that. She can do nothing. She can in fact, go ahead and prosecute the case, and that is certainly what she will do. She also has this case from earlier in the week in which the judge got rid of a couple of some 4 different counts in the indictment itself. And she can decide whether to go back to the grand jury and seek to re-indict those counts, or she can appeal that as well. But on the issue of whether or not she could be disqualified, she can now go ahead and prosecute this case, as can her office. And so the significant event that happened this past week, based upon the expressed interest of Donald Trump and others, including the particular petitioner on the disqualification motion, to appeal that decision by Judge McAfee, finding that she did not have to be disqualified, finding that there was, in fact, not a conflict of interest. Expressing interest in appealing that, what does Judge McAfee do? What has he done as a part of his supervision of this case? He issued something called a certificate of appealability. And that certificate, again, an entry of an order by the judge there, permits the Trump defendants to take an immediate appeal of his order that permits Fani Willis to stay in the case. And so that will almost certainly go up on appeal. The Georgia Court of Appeals, of course, has to agree. They have to grant, if you will, their own writ of certiorari to hear the case. But the judge basically is saying, yes, I'll permit you to go ahead and appeal my decision, finding that there is no conflict of interest here. This process could take weeks. The actual appeal, of course, could take months at a minimum. And so what it appears is that while this case is going up in appeal, even so, Judge McAfee not going to be staying his own conduct of this trial. It looks as though, at least for now, he's going to continue to handle the proceedings in this case and move it forward, although he has not yet set a trial date. And so we've got all these things happening in Georgia. This case, of course, different from the presidential immunity appeal in the D.C. case, keeping all of this straight, which pauses the work in the trial court in that case while the Supreme Court issues ultimately its decision on immunity. That's the matter that's going to be argued before the Supreme Court in later next month, in the month of April. A couple of final things here as we begin to conclude our broadcast this morning. First of all,
want to make a programming note, and that is in the Maggie Dawn Show coming up this Friday, the 29th, I'm going to be serving as a guest host back here in the studios with my great producer, Anya, from 2 to 4. We're going to talk all about voting during the course of that program. 4 days before the election on April 2nd. I thank Maggie, the producer, Anya, and all the members of the staff of Civic Media for giving me that opportunity. Join us from 2 to 4 this coming Friday, the 29th. Beyond that, I want to say how much it has been a delight, not only to work with all the staff of Civic Media, including Anya, all the other great producers, the staff, the executives of Civic Media, giving me this wonderful chance to come into your homes, your businesses, maybe your cars as well on Saturday mornings, and especially in recent times for recasting, restyling our program to see some more modest changes in the future. Our new show called Amicus, a law review, again, focusing upon the major news stories in government, law, and the aspiration for justice. We'll go out today to give you some sense of our continuing music change. This is Michael Gunlock. He styled this wonderful piece called Crazy Blues, Jazz Piano Solo. It is the basis upon which we enter, and we also leave today our program, Amicus, a Law Review. Come back and be with us again next Saturday. Have a good week, everybody.
Your home for the Devil's Advocates. Weekday afternoons from 4 until 6 on The Shaw. 540.